My name is Allison Baker. I'm chair of Venable's Financial Services Practice, and I want to introduce you, our audience, to our webinar this afternoon, CFPB Enforcement and the Biden Administration. It promises to be a really interesting hour. As everybody undoubtedly knows, we are about to enter an era of what we expect will be a very activist CFPB, especially along enforcement lines. And I have with me today a panel of experts on this topic. My colleague, Andy Arculin, my colleague, Meredith Boylan, my colleague, Alan Denson, and my colleague, Erin Cass. And if each of you could please introduce yourself and tell us a little bit about what you do and what your thoughts are about enforcement. And then we will start our program.
So I guess I'm first on the alphabetical list. So welcome, everyone. Thanks for tuning in today. As Allison noted, this is Andy Arculin. I've been with Venable since 2015, and prior to that was at the Consumer Financial Protection Bureau, the CFPB, that we'll be talking about today. I was in the regulatory office, worked on a number of rulemakings, largely around the mortgage area. In private practice, I do a number of things. Most of my practice focuses on consumer lending, but a lot of that involves fair lending, investigations, fair lending assessments, and audits and so on. Also do a lot of examination, supervision, support, and work with the broader team on enforcement actions as well.
Meredith, if you can tell us a little bit about yourself and introduce yourself, please.
Hi, everyone. I'm Meredith Boylan. I sit in the litigation group and the financial services practice. I work closely with everyone on this call, specifically involving consumer financial protection investigations, counseling clients who have received investigative demands, whether it be at the state or federal level, and also helping with related litigation and other spin-offs of investigative demands and investigations themselves. So thanks very much.
Thank you. Alan and Erin.
Hi, I'm Alan Denson. I come to Venable by way of the federal government and private practice as well. I started off my career in Washington as an enforcement attorney with the OCC for around 5 years and have been in private practice for the last 10 years now, working almost exclusively helping companies respond to federal and state enforcement investigations, whether that start in supervision over at the CFPB or it just start in an investigation, and help the same cross-section of clients respond to litigation from the Bureau and other federal and state regulators as well. And I've worked with all types of companies from across the consumer credit spectrum, but a lot of small dollar lenders, title lenders, installment lenders, debt collectors, payment processors, auto finance companies, the whole gamut. I'm excited to be here. I think this is a great group, and we'll have a lot of interesting stuff to say.
Thank you. And Erin.
Hi, I'm Erin Cass. I'm an associate in the financial services group. I've been at Venable since 2015. I work with those on this call and others, focus on enforcement and litigation, working with clients to help them respond to investigative demands from federal and state regulators. I'm happy to be here. Thanks.
Thank you. I'm Allison Baker, chair of the financial services practice, and my practice is almost entirely enforcement defense in the consumer finance space, especially focusing on the CFPB. So today's program, we have a few things. First of all, we will be offering CLE credits. About halfway through, we will give you the CLE code. Today, we're going to be speaking about, we have an agenda. We're going to be talking a little bit about the leadership, the new leadership at the CFPB. We're going to be discussing very briefly some enforcement process issues. What do you do if you get a CID? How does that work? Kind of the first 5 things you should think about. We're going to speak a bit about some of the expected areas of focus where we think the CFPB is really going to spend some of its time, especially out of the gate, looking and rethinking maybe some of its prior enforcement actions, as well as kind of looking to build out some of its new doctrine and kind of bolster existing doctrine. I want to talk a little bit about today, right out of the gate, the current nominee for the Consumer Financial Protection Bureau Director role, Rohit Chopra. As all of you probably know, Mr. Chopra is currently an FTC commissioner. He's been an FTC commissioner since 2018. Prior to that, He was at the Department of Education briefly, but really the critical thing I think for Mr. Chopra, for Rohit Chopra, is that he was at the founders. He's really one of the founders of the CFPB. He was there at the very beginning. When some of us were on this call, we're also there. Andy and I were both at the Bureau at the same time. And Rohit started as the director and first student loan ombudsperson at the CFPB, which is really important because it was a role that was specifically designated in the Consumer Financial Protection Act. It was a role that was put in there in part by Elizabeth Warren, basically charged with overseeing, looking at, examining, scrutinizing the way student loan borrowers are treated in the marketplace, all components from origination to consumer, to collections, to servicing. And without a doubt, as Meredith will talk about shortly, student lending, and in particular student loan servicing, is going to be a big focus of his. But the reason it's so critical that Rohit was there at the beginning, Mr. Chopra was there at the beginning, is because he really understands kind of the DNA of the CFPB when it started, and kind of it's kind of in his bones, if you will. And I think that we're going to see a renewed interest in not only using all of the tools in the proverbial CFPB toolkit, but a renewed interest in really looking at enforcement activity and meaningfully using it to build out the doctrine. What I would call the unfairness, deception, and/or abusive acts or practices doctrine, which is, of course, the CFPB's indigenous enforcement authority, meaning it can enforce other, 18 enumerated consumer finance laws. But UDAP is really the area where it has the ability to kind of build out its doctrine and really create a common law, a group of cases that establish the scope and authority of the CFPA's UDAP authority. And just like the FTC has done, we expect that enforcement will be charged with doing that going forward, much as Director Cordray had enforcement doing during his tenure. So I think that that's very important. The other thing that I think is really interesting and important about Rohit Chopra is that he's not an attorney by training. He'll be the first one to work at the CFPB in the director capacity who's not an attorney, which means a couple things. It means he has an MBA, which means he understands, presumably, maybe from a different perspective, how businesses and its leaders make decisions. It also means that in addition to taking enforcement very seriously and understanding its kind of, the push and pull of enforcement, he also will probably have a different view of instances when perhaps litigation or enforcement are not the best tools in the toolkit. When you're a litigator or a former prosecutor or somebody trained as a lawyer, you often tend to see that first. And I don't know if that will always be the case for Rohit Chopra, although I do expect, nevertheless, that enforcement will be something that he and his group are quite focused on. It's interesting because during his confirmation hearing in front of the Banking Committee on March 11th, 2021, he of course submitted written questions, responses to written questions, but he also gave some very deliberate and thoughtful responses in real time to questions that were asked of him by members of that committee. And he really focused on a lot of things. He talked about kind of the push and pull of innovation and data and how you kind of marry up those concerns with consumer protection, which I expect will be a theme of his tenure at the Bureau. He talked a fair amount about student lending. He talked about his interest in consumer protection, his interest in making sure consumers are protected, especially in light of COVID and kind of what's happened in our country economically in the last 18 months. I think that that's going to be a big theme for him, as he indicated. And so I think that you can look at his committee testimony, both written and verbal, and get a sense of where he's going. But I think we should also keep in mind that he understands the Bureau very well. As I said, it's kind of in his DNA. He really understands how it operates. He was there at the beginning, and he's going to be given a fair amount of latitude, assuming he does get confirmed, which we expect he will. But nevertheless, in the interim, there's an acting director who's also been quite active. And Andy, if you can maybe talk to us a little bit about him and your knowledge of some of the work that he's been working on.
Sure. So I think just to frame things up a little further regarding Rohit's nomination and so on. So Dave Waggio is carrying the torch right now. He's the acting director, as Allison noted, and he both of them are very much from the Elizabeth Warren school of thought. They both were at the Bureau when Allison and I were there back in the beginning, and Rohit obviously was at the FTC for a while. he's been a very tough advocate, a very tough commissioner at the FTC. And, I think there's folks in the industry expect him to be just as tough at the CFPB. Some of the statements that are made now, these really signal a shift in direction for the Bureau from the last couple of years. And I think there will be some subtle differences to the Cordray era, but some similarities as well. And if you look at some of the statements that have been made just coming out of the gate, this is January 28th. So this is really just fresh after the inauguration. Basically, there is a new sheriff in town. We're back. Get ready. And there's a number of things that we'll drill down on over the next couple of slides. On this one, one of the first things that Dave mentioned was, they have an exam record going back to last year before this change happened, that relates to COVID and the CARES Act and these various laws that the CFPB administers that intersect directly with the CARES Act. A few things I'd tease out that you can see on this slide. There's a message to mortgage servicers. The CFPB has, in addition to UDAP, which Allison talked about, there's extensive rules and Regulation X about loss mitigation. And there's also a federal statute, the CARES Act, that expanded rights for tenants, for borrowers, and so on. The CFPB they've gone through some examinations around COVID. They've looked at some of the practices. And a few of the themes that you can see just in the public statements that have been made, there's concerns about how mortgage servicers have processed forbearance requests or loss mitigation requests. There's concerns about the way that servicers in general, not just mortgage servicers, but really any loan servicers have treated borrowers who are in deferment or who have been told that they're in deferment, but the system maybe didn't align with the communications back to the borrower. There's student loan servicing, which again, this will be an area moving forward. And again, this is not just private student loans. This also relates to government student loans and how they're serviced, where it's a different bar. The CFPB under Kraninger was more hands-off. Now the Chopra administration is coming in with a renewed focus on it. And you'll even see it at the bottom. There's a mention of PPP loans, business loans, not what you normally think of the CFPB being involved with, but they do have authority under ECOA that extends to business lending. And there's some concerns about potential disparate impact in the PPP loan application process that the CFPB will look into, which, again, isn't necessarily what you expect the Bureau to focus on, but it's a signal that will be an area of focus for them as well. We can advance to the next slide. Again, there's been lots of statements about COVID. There's also statements about fair lending. You'll see you'll see CEFL coming back, SEFL, which is Supervision, Enforcement, and Fair Lending. Recall that under the Mulvaney and then the Kraninger administrations, the Fair Lending Office was basically pulled out and put under the director. It has been given a new mandate, new authority. Everyone in the industry expects Patrice and her group to be very active in the coming months and years. And fair lending is going to be a focus really across the board, and not just fair lending, but equity in general, which we'll talk. I'm foreshadowing a bit, but we'll talk about that later on in the presentation. A few other things to note: the CFPB, again, more shifts in direction being signaled by the acting director. There was a debate as to whether the Bureau had authority to supervise and examine for compliance with the Military Lending Act. And the CFPB had made statements that perhaps they did not have the authority under Kraninger. That's being walked back, and the CFPB is expected to aggressively examine and enforce the Military Lending Act. Again, this theme of racial equity, I think that really transcends everything the Bureau does. It's not just going to be fair lending. That's obviously going to be an area of focus, but racial equality, racial justice, low to moderate income, those themes, protecting the vulnerable, so to speak, are going to be throughout everything that the Bureau does for the coming years. With fair lending obviously being a big enforcement priority, but more than that as well. And even getting into some of the actions the CFPB's taken around the CARES Act. Just recently they did a rulemaking on Monday and it was about eviction practices and debt collection. But there is a mention of the practices being addressed having an impact on minority communities and low to moderate income communities. So expect to see that throughout everything that the Bureau does, and that's consistent with what the acting director has said.
So one of the questions that we have from our audience is when we expect Rohit Chopra to get a vote and to get confirmation. And I think part of it probably hinges on the Federal Trade Commission and kind of what the status of various appointees, nominees for those positions are. I don't think that the Biden administration, at least in the last couple of hours, I haven't seen it if they have, has announced the third Democratic commissioner nominee. Becky Slaughter, of course, is there, and Lena Khan is scheduled to be nominated or has been nominated. And so I imagine that part of the thinking around this is waiting for that. And then, of course, presumably Mr. Chopra's confirmation nomination would go to a full vote with the Senate. I do note that when he was voted out of the banking committee, it was a 12-12 vote. So it was evenly split along party lines, which I don't think is a big surprise, especially given his close alliance and he's closely aligned with Elizabeth Warren and others who were there at the beginning of the CFPB, and he will be a pretty assertive director. In that vein, and kind of preparing for what we expect will be a substantial uptick in enforcement activity, especially along the lines of receiving civil investigative demands, which of course are the precursor of the beginning of investigations, not always, but often. I'm wondering, Aaron, if you can kind of walk us through a few things. One, what is a civil investigative demand? And two, kind of what are the first few things that any party that receives a CID, unfortunately, because they're not great gifts to get, not a Christmas gift when you get one, but what you should do when you get a CID. And let me just give a tiny bit of context to this. So the CFPB has the authority to enforce the consumer finance laws, the enumerated consumer finance laws, as well as its own indigenous UDAP authority prohibitions against unfair, deceptive, or abusive acts or practices. It can send a CID, however, to any party that it believes may have information about a potential violation of those laws. So it doesn't just send CIDs to financial services companies. It doesn't just send CIDs to companies that are the subject of its investigation. It can send CIDs, and it has pretty broad-reaching authority in that vein. And it is always, or not always, but often, nearly always, the way that investigations at some point either get started or become more fulsome. So investigations can start with supervision, and we'll talk a little bit about that shortly. But the more fulsome way investigations kind of really bloom and blossom in the Office of Enforcement is through a CID. And it's really important that you be meticulous if you ever get one, and you really make sure that you kind of have very specific protocols in place for what to do. And so, Aaron, I'm hoping you can walk us through some of those and give our audience a sense of what to do if they ever find themselves in that situation.
Sure, thank you. So first, what is a CID, or civil investigative demand? Essentially, it looks a lot like a subpoena. It will start with a notification of purpose at the top. It will go through and list certain requests. Oftentimes, it's requests for documents, requests for information in the form of interrogatories. There's sometimes requests for tangible items or requests for written reports. So the first thing when you get a CID is just to read it really carefully. You want to look at the notification of purpose. What does it say the Bureau is investigating? Look at the applicable time period. What period of time do the requests cover? And in addition to looking at the requests themselves, but look carefully at the definitions and instructions. What terms does the CID use, which may or may not comport with terms or concepts that you actually use in your business? The second thing you're going to want to do is look at the deadlines. So there's really three kind of important deadlines to start with. One is the return date of the CID. Usually it's 30 days, although oftentimes this is extended. The deadline to meet and confer with the Bureau about the requests is within 10 calendar days of receiving the CID or before the deadline to file a petition to set aside. And then the third one, which I just referenced as well, is the deadline to petition to set aside or modify the CID. And this deadline is usually within 20 calendar days of service of the CID, or if the return date is shorter than that, it's the earlier of those two dates. The third thing that I think is important to do is you want to consult internally and with your counsel about the requests. And there's sort of two purposes in this, I think. One would be just to better understand the focus of what the investigation might be and where there might be exposure. And two, you're beginning to collect information in order to prepare for the meet and confer and any requests for modification within the requests. You're also thinking about what steps you need to be taking to collect documents, identifying relevant custodians, those kinds of details. I would say that the next step would be and this should happen, I would say pretty quickly, is you want to issue a litigation hold to make sure that you're not inadvertently losing any documents that may be responsive or relevant to the investigation. So this would include stopping any automatic deletion policies. Email retention is a big one, but also thinking about if there are paper documents that may be somewhere that are at risk of being destroyed, or if there are other methods of communication, shared drive, other types of documents or information that is at risk of being lost. And it's important to think about this broadly, think about the topics broadly, think about the relevant custodians broadly, and make sure that you're documenting what you're doing to stop any of those policies or practices where you might be losing information. And then finally, you're going to want to prepare for the meet and confer with the Bureau and any requests for modifications. And this conversation with the Bureau, which, as I said, has to happen within 10 calendar days of the service of the CID, is an opportunity to talk to the Bureau about the investigation and the requests. It can be an opportunity to find out more about the investigation and whether you're a target or not, although how much information you get during those meet and confers can vary. And then talk about the requests and where you might want to seek modification of those requests, including requests that are too burdensome to comply with, if there's a way that they can be narrowed, if there's a way to narrow it by time frame, for example, and also thinking about whether the requests are relevant to the investigation. And then this is also generally where you'll start to ask for, think about it, a production schedule. Generally, as I said, the return date is usually about 30 days, which oftentimes is not enough time to at least to finish responding to the CID, although you may be able to respond to some requests, but especially where some of these requests are broad and involve review of ESI. And this is where you'd start to talk about what that production schedule might look like based on the request for modification, and then follow up with a written request for modification. And then you'll receive a response from the Bureau that either grants or denies those requests. So those are generally kind of the first few steps, I think, that happen when you receive a CID.
That's really helpful. Thank you. And it's important to be quite methodical about how you approach a CID because you really do have very short timelines in play, and they're statutorily or regulatorily mandated timelines. So even if you can get extensions, you still do have to be mindful of those timelines. But once a CID has been issued and you've kind of engaged with these initial processes, there's a whole process in place for the investigation itself, producing documents, sometimes producing testimony, et cetera. And Alan and then Aaron also, I'm hoping that maybe you can help us, kind of go through some of those steps around investigative process, including the NORA itself, and some of the things that companies and individuals who receive CIDs from the Bureau should be thinking about.
Sure, thanks, Allison. So looking back at 10,000 feet, think of an investigation. The initial start of it is that the Bureau is gathering information. They're going to use the tools of discovery to get information so that they can build a case, whether that be having you respond to interrogatories, having you provide data, having you provide documents, having you provide testimony. And it's gathering information, and it's trying to build a case that's outlined in a notification of purpose that Aaron spoke about that's in the beginning of the CID. But it's often not the case that you just receive one CID and then that's it. Companies that I represent frequently have multiple rounds of CIDs. They get asked clarifying questions, and at every stage in that process, we're trying to tell the company side of the story early and often about why we don't think there are violations, why we think the Bureau's requests are too burdensome, and kind of try and help move the case along. But ultimately, if an investigation does not close, the Bureau will come to you and say, look, we think you have engaged in these violations of law. And we're going to give you a chance to write us a written response about that. That's called a NORA, as Allison referred to, or your notification of opportunity to respond and advise. And really, the way to think about that is it's like a legal brief that you're submitting to the Bureau. It's going to go to the enforcement team, to their supervisors, and will be reviewed in an enforcement recommendation all the way up to the head of the Bureau, either the acting director now or the director once we have a confirmed director. And even at that point, that doesn't mean the investigation is over. They're going to think about your response. You may get some additional questions after that. I've even gotten CIDs before for other clients after we've submitted the NORA. And at that point, ultimately, the Bureau will make a decision on what charges it's going to move forward to, if any, and they will come to you and say, look, we have authority either to reach a settlement or to file a lawsuit against you, and you can decide whether to reach a settlement with us or not. And usually there will be a round of negotiations or several rounds of negotiations. And then if that is not resolved, the Bureau has a choice either to file administratively or to file in district court. And I'll let Erin jump in, and I'm sure you have something to add as well here.
I was just going to add that I think, and I think Alan sort of alluded to this already, but I think that as the investigative process continues, it's sort of about thinking about it, I think, in two ways: from a macro level, what's your strategy, what's your narrative, how's the substance of the information you're giving them supporting your narrative or hurting that narrative, and how can you shape that? And then also on a micro level, really being methodical and organized and making sure you're staying on top of deadlines, because a lot of times there are several deadlines, there may be multiple CIDs, and you really want to make sure that you're sort of putting your best foot forward in terms of cooperating with the information with the Bureau and the information they're seeking, and but also controlling that narrative at the same time.
Yeah, you both have said something that I think is really critical. And Alan said this at the beginning. It's really the taking of evidence, as I always describe it. It's litigation without process. That's essentially what investigational hearings and civil investigation demands that seek documents and information are. It's all of the component parts of discovery in a litigation without the process that often accompanies that discovery and litigation. For example, in investigational hearings, a deposition without objections. And so, to Erin's point, it's very important to always have in your mind, even if it's an evolving macro theme, because it will evolve as the facts and the evidence come together, but it's very critical to have in your mind an understanding of kind of the macro theme or themes, a narrative that you want to make sure you understand is both apparent from, or maybe not so apparent from, the evidence and documents and materials that have been provided to the Bureau, but that you also understand kind of where your pressure points are, so that you can affirmatively work, hopefully, and use some opportunities to direct that narrative or change its course. And those are really subtle things that happen during the course of the investigation that I think are mission critical. If you want an investigation to get closed, or often they don't get closed, but you can have narrower, more confined injunctive relief or a settlement that has a smaller dollar number, it's really important to be mindful of those macro and micro points throughout, as Erin pointed out and as Alan pointed out. And Meredith, you've negotiated, for better or for worse, a lot of consent orders. You've done a great job with all of them. I say for better or for worse because, parties never want to be the subject of a consent order. Can you talk to us a little bit about some things to think about with respect to consent orders and proposed consent judgments, and of course, the alternative of litigation if one of those events doesn't happen successfully?
Sure. Thank you. So yes, in a perfect world, you've controlled your narrative and you're able to dissuade the Bureau from taking any further steps and walking away from your matter. However, what we saw under the prior administration was a pretty aggressive Bureau, and we expect that that's going to continue under the new administration and perhaps most likely be revitalized and revived. And ultimately, in many cases, unfortunately, the end result is a consent order, or probably to a lesser degree, a proposed consent judgment, and then even, sometimes more infrequently actual litigation. With respect to, just as a point, the difference between the consent order and the consent judgment is the consent order is an administrative process. The consent judgment is filed in court, typically along with a complaint, and the judge has to ensure that the proposed consent judgment is fair and reasonable. In most cases, the proposed consent order will be generated and circulated by the Bureau to you, and it will have a very, in our experience, typically a pretty inflammatory set of initial factual statements or factual allegations and charges and injunctive relief, and usually a pretty high dollar number as far as the monetary relief. And that monetary component could be in the form of a civil money penalty, or it could be in the form of restitution, which is contemplated as providing relief to the consumers who were affected by the alleged bad acts in the consent order. Hopefully by the time you get to the consent order process, you have developed some sort of working relationship with the attorneys on the Bureau side, and you have decided and determined what your leverage points are, what your strong points are, and kind of come to an internal consensus as to your bad facts. Sometimes there are bad facts and you have to figure out how you're going to grapple with them. And then there's, it could be months of back and forth with the Bureau on how to really fine tune those allegations. So the Bureau, nobody's going to leave happy, but that the Bureau gets, to get its message out, and that you also, though, are able to advocate for your client and soften parts of that narrative, and soften the financial hit and the conduct provisions. Of course, there's this concept of regulation through enforcement. So sometimes there's only so much wiggle room you have as far as really taking the teeth out of a consent order. The Bureau, in many instances, I believe, uses those orders as a tool to regulate an industry, because they know that everybody's watching. So if you are in, for example, the debt collection industry, and a consent order comes down from a big player, you're going to pay attention, and you're going to want to make sure that you're conforming your conduct to, the good conduct that they're setting forth in those conduct provisions. As far as the end game, in most cases, you would try to expedite or seek a more expedient resolution through a negotiation and agreed mutually beneficial consent order. However, every once in a while, cases do proceed to litigation, and in that instance, you're going to need to be prepared to go through, a full-blown litigation process. You've already felt a lot of pain because the CID process has forced you to collect those documents, gather that information. But in the event that the case does proceed to district court, you will have to be prepared for additional discovery, and their theories may change. They will reserve the rights as they're proceeding along in their investigation, and they'll use this as potentially a leverage point for their side to say, you can sign this consent order, and these are the 4 counts that we're going to allege in the consent order, and we're going to go after you for. But if you go to trial, we have 7 other theories that are sitting in a binder ready to go, and we'll get more discovery, and we'll pursue those, and your exposure is going to be exponentially higher. So it's a toss-up as to your strategy, but those are all viable options.
Thanks, Meredith. Two things kind of popped into my mind when you were talking. One is that, the Office of Enforcement at the CFPB is kind of a unique type of enforcement office as regulators, as financial services regulators go. And it's unique really for 2 reasons. One, it's unique because it's staffed by people who are actually litigators and trial attorneys. There's a whole bunch of former Department of Justice attorneys, line lawyers, and trial attorneys from Main Justice, as well as assistant U.S. attorneys and assistant district attorneys, prosecutors from other, state, local offices. And so the people who are in that office really understand how to litigate a case, and they really understand how to put evidence together. And a lot of them are very aware of kind of the push and pull of that. And indeed, were hired because of that expertise. So it's important to kind of, when you do get one of these CIDs and it does proceed further into an investigation, to kind of keep that in mind, because that is a little different than some other regulatory agencies. The other thing that I think is important to note is, like a lot of enforcement agencies, especially DOJ, the Bureau is not afraid to lose a case. They will take a case, even if it means they may not get the best outcome, because they want to establish a precedent. And that's very much an ethos that comes from the Department of Justice. And I used to work there, so I say that. And I think that that's really important. Those two components are going to drive a lot of enforcement activity going forward. And then I think the other thing that is really unique about enforcement is that, unlike other banking regulators, for example, the Office of Enforcement sits parallel with the Office of Supervision at the CFPB. It's what Andy spoke about earlier: supervision, enforcement, and fair lending. Those offices are all parallel, meaning that supervision and enforcement are kind of co-equals. And so it's not the case that supervision only gets cases, or enforcement only gets cases from supervision, but sometimes it does. And when it does, those cases are often pretty, they have a lot of good facts already in them if you're the enforcement office, because the examiners on the ground in supervision have done a pretty comprehensive job of fact gathering, although sometimes those are often followed by subsequent CIDs. But Andy, I'm wondering if you can, give us some insight from your days at the Bureau and from your current work about the understanding of the interaction between supervision and enforcement, and how that process works a little bit more.
Sure, happy to. So it is an interesting dynamic. As Allison noted, the enforcement office is really built like a prosecutor's office. You have basically folks who are wired to send out investigative demands, perform investigations, and then pursue enforcement actions, and if necessary, go to trial. They do sit parallel with the supervision office, who's more like a bank regulator. For supervised entities, granted, the CFPB has authority well beyond supervised entities. Now we're talking about financial institutions that have a sufficient asset size to be CFPB supervised, specific types of lenders and other industries, and larger participants that have been subject to a larger participant rulemaking and actually go through CFPB examinations. Granted, the CFPB, it doesn't examine all of its entities every 6 months or even every year. It has a ton on its plate, and it is a large office. There are regional supervision offices and so on. But once you're in an exam cadence with them, they do come in and examine. And they, like any examiner, you have limited privilege. It's not civil discovery, or it's not an investigation where it's adversarial. And in fact, if you make it that way, that usually doesn't end very well for you. So it's important to have a good rapport with your examiners, basically a trust relationship with them, but at the same time to be prepared, because if you're not, and what we're starting to see more and more with every passing week is companies that thought they were good with the Bureau for the last couple of years, because they didn't have any of their examinations result in a matter requiring attention, or what's called a PAR letter, which is basically when the supervision office escalates a matter to enforcement and gives you an opportunity to respond before they bring an enforcement action. There wasn't a lot of that the last few years, because the Bureau was, they had made statements saying that they were looking for good faith efforts at compliance, and a much lower bar than what we saw when Cordray was in charge, and what we're seeing now. But to this this escalation process, what can happen, and what often does, is the Bureau sees conduct that it finds objectionable, or it thinks violates any number of its statutes, whether it's UDAP or one of the specific, what I call the alphabet soup regulations that they examine for. And then they escalate to enforcement. And by that point in time, you've already tried to defend yourself. And it's if it results in an enforcement action, it's almost, I wouldn't say it's always a losing battle, but at that point in time, the CFPB's already got enough that it's proceeding, and it's not just on a fishing expedition like it may be with the CID. And that, that does result in, a different dynamic. What I find working with the other banking regulators is often enforcement actions are after your third or fourth notice, right? If you're not getting the message through supervision, then they come at you with an enforcement action. Whereas the CFPB could really, and again, I think this is already happening, they can look back at the last couple of exams and see conduct that someone made a note of, and they can pursue an enforcement action, or they can come in through the next exam and be tougher on you than they were last time. And again, I think that's a trend we're going to see over the next couple of years.
I agree with all of that. I think that it goes without saying that some of the earlier tensions, and Andy, we've talked about this, when we were at the Bureau, when it first started, there were a lot of unknowns, right? The first unknown was, would the agency exist 2 years out? The second unknown was, what kind of agency would it be? Would it be an enforcement agency? Would it be a supervisory agency? Would it be a rulemaking agency? And I think that the tensions in particular between supervision and enforcement at the very early stages of the Bureau, and tension, I don't mean adverse relationships or disagreements, but adverse relationships or disagreements. I mean, a tension in terms of perceived tools and what was most effective. And I think that there's kind of a sense now of equipoise that both supervision and enforcement serve mission critical roles. And we increasingly see in our practice a real interconnectedness between those two offices. And I don't think that a new group of people coming in, a new administration under Rohit Chopra, that's going to change. If anything, I think that that's going to get reinforced, because you're going to have somebody who kind of knows the Bureau. It's kind of in his bones. It's in his DNA, as I said, coupled with this more mature agency approach of kind of figuring out the balance between enforcement and supervision. I think you're going to continue to see an uptick in enforcement actions that grow out of exams. Examinations are very effective ways to gather facts. They're not inherently adversarial, as Andy said, and there really isn't a lot of pushback. If your regulator comes in and demands something through a request, an IR, you have to give it to them. And once you give it to them, if there's something in there that goes above matter requiring attention in MRA, it often does get kicked through the par letter process and through the ARC process to enforcement. And enforcement it's not being kicked down or up, it's being kicked across the hall, because enforcement and supervision are co-equals. And in that vein, I think it's important to keep that dynamic in mind as we talk a little bit about some of the areas of focus that we expect the Bureau to really focus on, especially through enforcement, but not only through enforcement in the next, call it couple of years. And I'm going to go through the list, and then each of us is going to speak briefly about these different topics. So we continue to expect and see an enhanced interest in the way that consumers have been treated during the pandemic, to what Andy alluded to and spoke about earlier, and other components of that agenda that we think will become more substantial once Rohit Chopra arrives. Fair lending and equity. Clearly, those are issues that are critical to both the Bureau's existence. They go to the core of the Bureau. If you look at its founding statute, equity as a general rule and kind of protecting vulnerable populations is kind of mission critical to the Bureau. Its abuse of authority is designed to protect that. Student loan servicing, which of course is one of Mr. Chopra's critical issues that he cares deeply about. He knows a lot about. He talked at length about it during his banking committee hearing. Small dollar lending and the payday rule, that I think is going to be an example of kind of reneging the old Craniger Mulvaney tenure, and really maybe returning in some ways to the Cordray tenure. And we'll see that, I think, through the focus on that. And then non-bank fintech companies, we'd be remiss if we didn't talk about the enhanced scrutiny that the Biden administration in general is bringing to technology companies, especially those that are large, but also those that are smaller. And of course, we're seeing a movement among other regulated entities for, kind of quote, leveling the playing field, unquote. And I do think you're going to see, a Chopra administration be open to more scrutiny of non-bank fintech companies. And we're going to speak about each of those a little bit more granularly. I'm going to speak a little bit about COVID. So we spoke about this at the beginning, kind of looking at the kind of the sea change that happened on January 21st, starting there. Really a very, very, very mission critical interest in making sure that during the last 18 months of the pandemic, and this will probably go forward for another 2 years, how have consumers been treated in the financial services space? So if you're a financial services company, you have a consumer-facing product or service, and you had a obligation or an opportunity to engage with consumers during the pandemic, how did you engage with those consumers? This is particularly critical, I think, if you are on what I call the credit continuum. If you extend credit through origination or some other mechanism, you are servicing credit, your collections, your furnishing, or your reporting. if you're doing one of those 5 things in particular, not only those 5 things, you are particularly, I think, susceptible to scrutiny around how your processes and protocols that are consumer facing interacted with consumers during the pandemic. Number 2, if you are providing a financial product or service to consumers that is not a financial product or service that a consumer necessarily selects, namely servicing, furnishing, collections, the Bureau is particularly interested in how you have responded to and treated consumers, especially during this time. They've always conceived of those products or services in kind of a separate category. I used to hear Rich Cordray talk about this a lot, because the idea that the market somehow could correct and consumers might naturally choose a more positive consumer-facing experience. Well, they don't choose who their servicers are. They don't choose who their collections companies are. They may not choose the furnishing mechanism. So the Bureau is very focused on those things, especially as they concern the pandemic. The other thing the Bureau is very interested in, and we saw this in the July 2020 Consumer Complaint Report, is instances where consumers have used different kinds of products or services that aren't bank products, but they function like bank products, namely through prepaid cards, for example. There have been a very substantial uptick, and we saw this particularly in the spring and summer of 2020. If you go back and you look at their Consumer Complaint Report, that was the first one they issued around COVID, the Bureau was seeing a substantial uptick in consumer complaints in the prepaid card space, to the extent consumers were using prepaid cards as mechanisms to receive some kind of government money, or they were otherwise using those prepaid cards because everyone was kind of remote, virtual, hands-free, and contact-free, if you will, contactless. The Bureau continues to be very interested in those issues as well. So the way prepaid cards work and the way consumers are being treated vis-a-vis use of those cards. And so I really do think that those are issues that are going to continue to percolate at the Bureau. And if anything, we're really going to see the kind of, the way that the pandemic has treated consumers from an economic perspective. We're going to really see scrutiny around that, I think, in about a year, because the full impact of the economics of the last 18 months will be felt at that time. And enforcement offices everywhere, particularly at the CFPB, will be doing a look back around that. And so it's not an overstatement to say that if I'm Rohit Chopra and I walk into the office on the very first day, that's number 1, 2, and 3 on my agenda. Apropos of this discussion, number 4 on my agenda, and just as important, are fair lending and equity issues, particularly because, as Andy was discussing, fair lending concerns were kind of put in a different bucket during the Craniger years. And so, Andy, if you can talk to us a little bit about what you expect will be coming up, through the pipeline as well in that space.
Sure. So I'd kick this off by saying fair lending and equity is not just a priority of folks at the Bureau or Rohit Chopra. It's a priority of the Biden administration. It's a priority of Senator Warren. It's a priority of Congresswoman Waters, and so on. So basically, all of the key decision makers in Washington right now have this at the top of their list. And it's expected to be, if not the focus of the Bureau in the coming years, one of the top 3. And you can even see there's a statement here from April, the Fair Lending Report, that said there's a number of ongoing and newly opened fair lending investigations already, and that we're just a couple of months into the change in leadership. So that's it's been coming down the pike. I think there's been a lot of angst about this. My thoughts on it in terms of where the Bureau will go. Like I said, it's a no-brainer to say that the Bureau is going to be much more active than they were for the prior years under Mulvaney and Craniger. If you look back, and it's on the slide, there really wasn't a whole lot of fair lending activity during those times, other than what happened through exams. There was, there's an enforcement action that's being litigated now, which was really about redlining, right? It wasn't disparate impact or something like that. It was really about redlining, and the allegations are fairly incendiary. Other than that, there were some, there were some actions around HMDA reporting and things that loosely touch fair lending, but not a whole lot since Cordray was gone. But as we alluded to before, there have been examinations regularly. The CFPB is monitoring the markets. And there's a theme at play right now, which really fair lending and equity both, which it transcends consumer lending, but it's certainly going to make fair lending a hot topic. Very briefly, because I think we could spend a full hour just talking about this subject. But in terms of what I think the CFPB is going to focus on, and I think even more importantly, what companies out there can do to protect themselves and get ready for it. I would say in the mortgage area, the CFPB over the last few years with some tweaks and adjustments expanded HMDA reporting to the point where your regression analysis that you do to determine your fair lending risk under mortgage is largely done today based on what's reported into a public database. So, keep that in mind because the Bureau has access to all of that information. They can basically mine it to their heart's content. You're reporting it to them now and so on. There hasn't been a lot done with it yet, but anything that relates to mortgage pricing is sitting there waiting for someone to take advantage of it. So that's an area of risk. I think servicing practices, particularly, as they relate to COVID, loss mitigation, forbearance requests, loan modifications, the whole 9 yards. That's an area that the CFPB views as being under its fair lending authority, as well as UDAP and Reg X and everything else. I expect there to be a lot of activity there. And again, the reports we're getting is that there already are some investigations happening. In just the regular lending arena, there's a increasing use of alternative data, alternative underwriting, all of these new algorithms that are out there, and sometimes they even just relate to marketing practices, not really credit underwriting. Those are going to be areas of interest from the Bureau, and the Bureau has made public statements saying that as well. And even, as I alluded to earlier, business lending, it's not what you normally think of the CFPB as focusing on, but they do have an interest in protecting, women and minority owned businesses from discrimination, just like they do consumers, and it coextends to those transactions as well. So, those are all going to be areas where the Bureau is active, they're investigating, they're examining, and so on, and will be much less reluctant to bring enforcement actions than they were before. And in terms of, to everyone who's thinking, well, this is coming down the pike, I certainly don't make a point to discriminate, but what can I do to protect myself? I think that's a fair question. I would say it's more important than ever to have a firm understanding of your data and your record keeping and the way that you make credit decisions, the way that you do pricing and so on. And in this, whether you're a mortgage lender, an indirect auto lender, a direct auto lender, a student lender, or an installment lender or a credit card issuer, they all are subject to these fair lending laws, and they're often put in different buckets during examinations, but will be analyzed largely along the same lines. And I would say it's important for every institution out there to understand, are there any practices that you have that have a disparate impact on protected classes? And if there are, then what is your line of defense? Can you explain your data to an examination team and explain why what you have in place serves a legitimate business need and there's no less discriminatory way of doing it and so on? That's a lot of work. We do a lot of work with clients to prepare for this. We usually work with statisticians and consultants and basically go through these analyses and prepare institutions to explain this stuff to the Bureau, because I do think the Bureau is going to be asking much more pointed questions in the future than they have been.
Thank you. I know we have a few minutes left, and before I'm going to ask a couple of our other participants to quickly give us their assessment of certain areas. But before we do that, I just want to make sure that we know the CLE code for today's program. It's CFPB 2021. CFPB 2021. So I'm hoping that Meredith, you can tell us, in a couple of sentences, your thoughts on student loan servicing. Alan, what you see coming down the pike with the payday rule, and then Aaron, if you can just kind of end our presentation with a little bit about a renewed interest in technology. Thank you very much for joining us today. Go ahead, Meredith.
Sure. So building on Andy's remarks and the discussion thus far, I think the student loan servicing space also brings to mind all of these equity considerations. We know that there's been a focus on protecting students of for-profit institutions, students who have just seemingly unmanageable debt. And it looks like from, based on Mr. Chopra's prior remarks and some of the signals that we've been getting from the Bureau to date, including the acting director, that they're going to be taking all of these into consideration, that they'll be looking at federal programs, both the income-driven repayment options and public service options, and also focusing on private lenders to make sure, and private servicers of private loans to make sure that they are adhering scrupulously to the regulations that are in place. One of the points that I think will be a renewed focus or a new focus is communication. That seems to be a real sticking point with the Bureau as it stands and as it's going forward. Making sure that lenders, both in the COVID context, are communicating with their borrowers about what their options are, what the rules are, what the rules of the road are going forward. It's been, there's been a lot of developments in the student loan area as a result of COVID, and how we're going to move forward. And also just making sure that you're on top of those consumer questions, consumer complaints, monitoring the CFPB complaint database to make sure that you're sufficiently being responsive to consumers, because that seems to really be, one of those administrative, it seems ministerial, but it's actually very important to the Bureau. I'm going to move so Alan has some time as well.
Okay, small dollar, very briefly. There was a rule that required payday and other small dollar lenders to assess a borrower's ability to repay. That was rescinded during the Mulvaney and Kraninger administration, and there's still litigation ongoing about the payment provisions, but that's really neither here nor there for purposes of this slide. Last month, the acting director came out and said, look, even though there's no longer an ability to repay provision for the small dollar rule, we still have our abusiveness authority, we still have our unfairness authority, and we're going to use that authority to address harms that are suffered through sustained use. We're going to monitor the market, we're going to use supervision, we're going to use enforcement, and if we get there, we may use rulemaking. And I think abusive acts in particular are a very real concern for small dollar. In 2021, right as the administration changed, one of the first things that happened is the acting director rescinded a policy on abusive acts or practices that essentially said, we're not going to use triple pled unfairness and abusive actions. We're only going to bring those cases where there's regulatory certainty and their standalone claims, and we're going to look at companies' good faith efforts to avoid abusive practices. That's gone now. And so I think I would look for more aggressive enforcement of the abusiveness prong of UDAP against small dollar lenders, as well as the sustained use section of the CFPB enforcement manual.
And Erin, if you can just give us a little bit of a sense of, your expectations around kind of Mr. Chopra's willingness to take on technology companies, as we've seen with the FTC. I don't think it's a secret that, his views on those things and how that could translate to the CFPB as well.
Sure. So I think just briefly, as Allison mentioned, there is a perception that there's a lack of a level playing field for non-bank fintech companies as compared to banks, which tend to be very heavily regulated. And as these non-bank fintech companies are developing and offering similar products and services as banks, they have received historically less attention from regulators. I think we do expect to see a renewed interest from the Bureau into these companies. They're going to look to increase regulatory oversight, focusing on a consumer protection standpoint, and then also just following up on some of the equity issues that we've been discussing, that there may be a particular scrutiny on products or services that have a bigger impact on communities of color, service members, older consumers, or other populations that the Bureau would consider to be vulnerable populations. So I think we can definitely expect to see some greater scrutiny from the Bureau on this specifically to non-bank fintech companies.
Thank you. Thank you so much, everybody, for joining us today. As you can tell, we could talk about these issues for an entire day, and we will indeed be having subsequent webinars on very specific, discrete issues around enforcement as we go forward the rest of the year. I want to thank you all for joining us. I'm Allison Baker, Chair of Venable's Financial Services Practice, joined by my colleague, Alan Denson, a partner in our Consumer Financial Services and Financial Services Practice, Andy Arculin, a partner in our Financial Services Practice, Erin Cass, an associate in our Financial Services Practice, and Meredith Boylan, a partner in our Litigation and Financial Services Practice. Thank you so much for joining us. This webinar and our slides will be available on our website, I'm told, next week. And again, our CLE for today is CFPB 2021. Thanks, everybody. Have a great afternoon. Thank you.